My lady and my lords, you may be surprised to see me standing. It's because I wanted to just come back to the issue about the preliminary reference and the court's ability to make it. There should be on the table in front of you a single-page document which has been agreed by the parties. And I don't know if you wish to take time to read it.
Mm-hmm. And paragraph 2, presumably, should also say, and the UK courts will not have power to make any references.
That's correct. Absolutely right.
It's not a question of whether we're bound by anything they say.
No, but no references can be made. And that's clear, actually, from Section 6 of the 2018 Act.
Yeah, absolutely.
And for your reference, you have copies of the Act and the withdrawal bill and the withdrawal agreement.
Oh.
And you can see the cross-references within this note.
Thank you. Thank you. Thank you.
My lady, might I then go back to two items of business left over from yesterday before moving on to issue 2. The first is the question of German translations, and in this context, I hope that somewhere near there's a piece of paper before you which, or two pieces of paper, one of which is the German version of the Calfellis decision, and another of which are extracts from a German English dictionary. And just to complete submissions or discussions yesterday, if one turns in the Calfellis German decision to page 5585 in the bottom right of the German Calfellis decision.
5585.
5585 at the bottom right of the German Calfellis decision, my lady. One sees paragraph 17, and the word that in the English edition was translated as liability is Schadenshaftung. I believe I mispronounced it yesterday by saying Schadenshaftung, but it's Schadenshaftung. And then in the answer at 5587, answer 2A, there is the word again. And then if, I hope you then, invite you then to move to the dictionary, which is the Gross Wörterbuch English. And hopefully the first page of that is under H. And we have Haftung. And is the second.
Liability.
Yeah. And jur relates to the jurisprudential meaning, I venture to submit. And then if one goes to the extract from S, which unfortunately is a little grey in the right hand of the page, but in the third column in the middle, one has Schaden. And that, the first definition there is damage, injury, harm, or infirmity. And then over the page, 869 at the top, about in the first of the three columns, about a third of the way down, one has Schadenhaftung, liability for damage. Now, the second item left over from yesterday is the case of AMT Futures, which I hope is also in a hard copy somewhere near to you. And my submission on this is that it supports the proposition that the connecting factor in tort represents a close connection between the disputes in the court of a member state. And can I invite you to look at the judgment of my Lord, Lord Hodge, at page 456 of the report, starting there for just a couple of statements of principle, which in my submission impact on both yesterday's and in fact on today's agenda. Paragraph 13 at the bottom of page 456 of the report. My Lord held that the derogations from the general rule, including Article 5.3, must be restrictively interpreted, and we've seen that a number of times. The derogating grounds of jurisdiction are justified because they reflect a close connection between the dispute and the courts of the member state, other than that which is in which the defendant is domiciled, and the close connection in tort is because of the place of harm. And then over the page at 14, my Lord held that it's necessary, in my view, to distinguish between the terms of a derogating ground of jurisdiction on the one hand and the rationale or justification on the other, as it is the former which confers the jurisdiction and not the latter. In my submission, that is material. And then the only other paragraph that I would just draw to your attention is page 461, paragraph 31. I won't read it, but there's a reference to the Calfellis decision, which in my submission is consistent with, albeit I can't say positively supports, my submissions on the correctness of Kleinwort and the true ambit of Calfellis there.
Yes.
My Lady, may I then come to issue 2 and 3, which I will take in that order? The context here is that both courts below were with the bank, my client, that the matter in this action was a matter relating to insurance, but were against my client on the basis that there was an exception in Article 14, which accepted from the benefit of Article 14 the bank on the grounds that the bank was part of a class which regularly dealt insurance claims and was therefore not a weaker party. So 2 issues. And I address now the first, as I say, where I was successful below. The Court of Appeal dealt with this in paragraphs 62 to 78 of their judgment, and I won't read those out, but my basic submission is that they were right for the reasons they there gave. And in this respect, we deal with this issue in paragraphs 56 to 103 of our case, and I will not orally address every point there, but we do rely on the points that are there. And the starting point is the wording of the regulation, which is, the regulation starts at page 792. That is Principal Authorities 1, tab 15. And if I can read all of the relevant parts now to avoid having to come back, therefore starting at 794 and recital 15, which is that the rules on jurisdiction should be highly predictable and founded on the principle that jurisdiction is generally based on the defendant's domicile. And that is the result for which I contend in this case. Then recital 18 at the top right column of page 794, in relation to insurance, consumer and employment contracts, the weaker party should be protected by rules of jurisdiction more favourable to his interests than the general rules. Then page 798 of the bundle, at the top of the left-hand column, I referred yesterday to Article 4, and at the bottom of the left-hand column to Article 7(1)(a). Just remind the court of the wording that it's in matters relating to a contract. Those are the words. I'll pass over the delict one. Then at 799, Section 3 in the left-hand column, Articles 10 to 14 are the ones immediately in issue. And this in Article 10 and in the heading is matters relating to insurance as contrasted with a contract or a contract of insurance. And then Article 11 is important because in my submission, all but one of the cases that my learned friend relies on are about either Article 11 or Article 13. And Article 11b reads, starting with Article 11, an insurer domiciled in a member state may be sued, b, in another member state, in the case of actions brought by the policyholder, the insured, or a beneficiary, in the courts for the place where the claimant is domiciled. So that is a derogation from Article 4 in favour of the claimant, but expressly the claimant who is a policyholder, an insured, or a beneficiary.
The same people as in Article 14.
Exactly so. Now there's a slight extension to that in Article 13.2. And in Article 13.2, it says that Article 10, 11, and 12, and therefore Article 11, shall apply to actions brought by the injured party directly against the insurer. So this is an extension of the benefit of, inter alia, Article 11(1)b to an injured party in case of a direct action statute. And some of the cases my friends rely on are about that. And then we have Article 14, without prejudice to 13.3, which relates to direct actions and not an issue in this case. An insurer may bring proceedings only in the courts of the member state in which the defendant is domiciled, irrespective of whether he is the policyholder, the insured, or the beneficiary. The same wording as in Article 11. And so this provides a derogation in Article 11 extended by Article 13, but a reaffirmation of the general rule of domicile in Article 4 and Recital 15 of the defendant's domicile. And the question in this case, question 3 will be whether there's an implied exception to that in favour of, in the case of a non-weaker party. But question 1 is whether the action in this case is a matter relating to insurance. And just in this context, may I invite you to contrast page 800, jurisdiction over consumer contracts, which is another derogation. That's what is now Article 17.1, in matters relating to a contract concluded by a person, the consumer, and then there's a definition. So there's a derogation there by reference to a consumer contract. And 801, Section 5, a further derogation in terms of, in Article 20, Sub-Article 1, in matters relating to individual contracts of employment. And the the legislative technique in the insurance case is therefore notably different from both Article 7.1a, matters relating to a contract, Article 17.1, matters relating to a contract concluded by consumers, and Article 21, matters relating to individual contracts of employment. By contrast, it's insurance, which is a more general proposition. Now, coming to matter relating to insurance then, and this is issue 2, the matter is the appellant's claim against my client, not the appellant's claim against the owners, but against my client. And the central plea in all parts of their claim against my client is that there was no insured peril. And therefore, there was no valid claim under the hull policy. And instead, there was an insurance fraud by the owner on the insurer. If there had been an insured peril, my learned friend's clients would be liable for that which they paid, because what they paid, pursuant to the settlement agreement, was the $22 million insured value. If there had been insurance peril, they would have no claim, because no lies were told, and in any event, they owed the sum insured. And my essential submission is that it is unreal in those circumstances to contend that this is not a matter relating to insurance, and that the court, the commercial judge, and the Court of Appeal, in essence, took that approach, that this is clearly a matter of relating to insurance. Now, can I then identify for you the nature of the underwriter's claim against my client by reference first to the particulars of claim, which start at page 351, that's core volume 2, tab 7I, at page 351 is the beginning page, and I would invite you to read this in context as a whole, but the passages I invite attention to now to try and identify the claim against my client starts at page 359, paragraph 52, where are set out the representations that form the basis of the claim in tort. And the representations are, in presenting the claim, Kairos and Zigana, acting on their own behalf and on behalf of the bank, and I've already made my submissions that they didn't, the courts below didn't accept the latter part of that, but this is the nature of the claim against my client, made the following express or implied representations. And in short, they are all about liability under the policy. The vessel was lost by reason of a peril insured against. The loss was accidental. That is material because in marine insurance law, the peril of perils of the sea is only engaged if the loss is accidental. So saying the loss was accidental means the same as one, it was a peril of the sea, unable to explain the cause of the loss, entitled to indemnity under the hull policy, and not guilty of willful misconduct. Now, 4 speaks for itself, entitled to indemnity under the hull policy, and 5 is because willful misconduct is an exception to liability under the Marine Insurance Act, section 50-something.
That would be an implied representation, wouldn't it?
Yes. They're all, yes.
Well, no, some of them are expressed, obviously.
Yes. Probably one is express and the other implied. But, my lady, in a way, express or implied, the point that applies to all of them is that the representation is there was an insured peril and a liability under the policy. And at 59, there is the falsity is pleaded. the vessel did not become a total loss by reason of a peril insured against. So representation, loss by peril. Falsity, no loss by peril. That's page 361 of the bundle. And then if I can invite you to go forward to 365 of the bundle, at para 62, there are the claims for relief. Now, 62.1, the avoidance or rescission of the settlement agreement, in light of the decisions of the courts below, that relief can only be claimed against the owners who were party to the settlement agreement and not my client who were held not to be. Restitution of the settlement sum, I'll come to that in a minute, and damages, and I'll come to that later. So as far as restitution is concerned, so at pages 365 through to the bottom of 366, there is the claim of rescission against the owners, not in light of findings against my client. And then at 367, under the heading 2, para 69, is restitution. Well, that is a claim against owners only, not my client. And 70, however, is a claim against my client, amongst others. Further, alternatively, the insurers paid the settlement sum to Willis on behalf of Kairos and Zigano and or the bank, and or for the benefit of Kairos and Zigano and or the bank, in reliance on the insurer's mistaken belief that, and then there are the same, essentially 1 to 5, the same particulars, which constitute the mistaken belief that there was loss by reason of peril insured against. There is also 6, the settlement agreement was valid, not voidable. And then paragraph 71, therefore the insurer is entitled to restitution of the settlement sum. Now 71 obviously applies to both 69 and 70, but so far as concerns as against my client, it is purely the mistaken belief that there was an insured peril, a causative insured peril. And my Lord Reid asked a very good question: how does this work in circumstances where the mistake was a payment to Willis on behalf of, as the court has found, on behalf of the owners, and the owners through Willis then paid it to my client? But we're not here debating how the cause of action might actually work, but what we're here debating is whether it's a matter relating to insurance. And then paragraph 73 is the damages claim as against my client, essentially. Had the said misrepresentations not been made, the insurers would not have concluded the settlement agreement, and by reason of the willful misconduct, the insurers would have borne no liability under the hull policy. And it's the latter of those that is the more important, because whatever misrepresentations or the status of the settlement agreement, if they bore liability under the hull policy, they would have no damages claim and no restitution claim. And that's clear from the because the insurers are not liable for loss attributable to willful misconduct under the section 55.2. That was the section I couldn't remember the number of a little earlier. And further alternatively, there's a forfeit of benefit, and further alternatively, there's avoidance of the hull policy, but once again, that wouldn't be a claim against my client. And 74 is the damage. The insurers have suffered loss and damage in the amount of the settlement sum. And in those circumstances, I won't read it now, but I'll give you the reference. Both the judge at paragraph 66 to 70 of his judgment and the Court of Appeal at paragraph 78 of its judgment, and that's at page 301 of the bundle, held, as a matter of analysis of my learned friend's claim, that it was in essence a claim of non-liability under the policy. Now, my lords, the court, my lady, the court, in my submission, should not reverse that finding, because it's a finding of all of the courts below. The commercial judge and the Courts of Appeal as to the nature of the claim. And but if that is a point for review in this court, then it's clearly right. Those findings below are clearly right on the wording of the points of claim and the substance of the points of claim. So, applying, and that is the matter in question, and applying that to the wording of Article 10, and that is clearly, on the plain wording, a matter relating to insurance. Now, in our submission, there is no European law definition of matter relating to insurance. There is no European law authority for any gloss on those plain words. And European law is that those plain words are to be applied naturally by the national court. And that is what the Court of Appeal and the judge did here. There is no point of European law here. European law is plain. Those are the plain words. It's merely a question of application to particular facts, which the judge and the Court of Appeal did unappealably or, if appealably, correctly. In that context, can I refer to the case of Cabeg, which starts at page 929 of the bundle, Principal Authorities 2, tab 26. And of the cases, of the European cases, this is the only one cited in this context. This is the only one which concerns matters relating to insurance. There are cases concerning matters relating to a contract, and there are cases concerning matters relating to a contract of employment. But this is it, so far as matters relating to insurance are concerned. And the facts of this, if I can summarize them essentially, but they appear from the head note at 929, is that Cabeg, the employer, continued to pay the victim of a car crash and thereby became subrogated or assignee of some of the victim's rights against the driver of the negligent driver of the car, and also entitled to bring a direct action against the insurer. And Cabeg was Austrian, and the insurer was French, and Cabeg brought the action in the courts in Austria. And this case is important, and I'll come back to it on the weaker party, the supposed weaker party exception. But for present purposes, then, one has a direct action under the relevant provisions of Article 13, which confer the benefit of Article 11. And the question was whether Cabeg, as the employer assignee or subrogee, was entitled to bring the claim in Austria under a combination of Article 13 and Article 11(1)(b). But to revert to that, the first point to note is that in this case, concerning matters relating to insurance, if one goes to 932 of the electronic bundle, that there was no reference to the Brogsitter case. And that's important because my learned friend's submission is that Brogsitter lays down a test governing matters relating to insurance. But if so, it escaped the attention of the Advocate General and the court in Cabeg. And then at 937 of the electronic bundle, in the Attorney General's opinion, paragraph 31, AG 31, it is what was stated about matters relating to insurance. At 31, the Advocate General agreed with the Commission that the notion of matter relating to insurance must be interpreted autonomously and uniformly. But 32, but apart from that general observation, indeed, there appears to be no EU-specific definition of a matter relating to insurance. So far, the case law of the court has provided two types of casuistic guidance in the matter, by inclusion, providing explicit examples of what is in, and exclusion, what is out. And at 938 of the bundle, AG 37, he provides what I might submit is a casuistic example of what is in. And his example there is that AG 37, in the context of Section 3, a matter relating to insurance then simply concerns the ascertaining of rights and duties of any of the parties referred to in Articles 9.1b and 11.2. That's now 11.1b and 13.2. And that is the policyholder, the insured, the beneficiary, and by extension, the victim. To the extent that these rights and duties are said to arise out of an insurance relationship. And insofar as that is in, this is a matter relating to insurance, because the question is of my client's rights as a beneficiary under the policy. If my client had rights under the policy, then there is no claim. And in my submission, the existence of the settlement agreement is merely one factual particular of the way the loss arose, the essential issue being, was there a liability under the insurance policy to the beneficiary? So that I may say, that is essentially it so far as the authorities before this court, specifically relating to matters relating to insurance in the EU. There is English authority of the House of Lords, however, and that is Jordan against Baltic at page 620 of the bundle. That's Principal Authorities 1, tab 5. And the head note is at 620, but can I summarize that? Jordan, the plaintiff, took out a policy with Baltic, the insurer, covering the risk of liability for prizes that Jordan may have to pay to its staff and drivers in the event that it did well at motor racing. And it then made a claim on the policy on the basis that it had to pay out bonuses and the like on the basis of success in racing. And Baltic defended that by saying that the whole claim was an insurance fraud, that they had faked up the sponsorship and prize deal. That was the defense against Jordan. They also counterclaims against Jordan in the English proceedings. But they also wished to counterclaim for fraud against an Irish company said to have been involved in the fraud and its 2 Irish domiciled directors. And the question was whether the Irish defendants to counterclaim, not party to the insurance policy and not originally claimants in the English proceedings, whether that claim was a matter relating to insurance, held that it was. In very simple terms, if I can just then direct the court to page 624 and the proceedings within the judgment of Lord Steyn, that's essentially where I've taken my short summary of the claim from. So that's where to cross-check what I've said about that. And then at page 625 of the bundle, between the letters E and F, the court, Lord Steyn, decides what is called the anterior question. Mr. Richard Southern, who appeared for the Irish parties, pointed out that there are 3 questions. It's essential to resolve the logically anterior question whether Baltic's counterclaim against the Irish parties is a matter relating to insurance within the meaning of Section 3 of the Convention. Baltic Insurance alleges an insurance fraud. Well, so here does my friend. It seeks to avoid a contract of insurance. So here does my friend, and as in the Baltic case, it seeks to avoid against the insurance company, but not against the Irish defendants, because the Irish defendants were not party to the insurance policy. And recover damages, so here. The Court of Appeal unanimously held that it is clearly a matter of insurance, relating to insurance, and that is plainly right. Now, what the House of Lords is doing there is applying the simple, plain meaning wording test that, as the Advocate General said, there is no EU-specific definition. So that, in my submission, is authority for the plain wording, don't gloss test. Now, having said that that's the only case about matters relating to insurance, I now submit that in this area, limited assistance can be obtained by looking at cases concerning matters relating to individual contracts of employment, insofar as they address the words relating to. And in that context, I invite you to look at the Alpha Laval case, page 1219 of the electronic bundle. That's Other Authorities 1, tab 41. 1219 is the head note, and I don't think the issue matters, that the facts matter here. So, if I may go straight to page 1227. It considers matters relating to an insurance contract. At 1227, paragraph 24, Lord Justice Longmore did not agree with the judge's restatement of the test as a legal relevance test. And in paragraph 24, his lordship went on to say, it is much better to stick with the actual words of Article 8.1 and ask oneself the question, do the claims made against an employee relate to the individual's contract of employment? This is a broad test which should be comparatively easy to apply. So it's the plain language, don't gloss principle again. And then Lord Justice, at page 1230, to similar effect is Lord Justice Davis, paragraph 43. The first half of that paragraph is talking about the legal relevance test. They refer to the GlaxoSmithKline principle that rules of special jurisdiction are to be interpreted strictly. And then this, that does not require ignoring the evident purpose behind the regulation, as exemplified in recital 13, and that is predictability and defendant domicile. Nor does it require giving Article 18.1, that's now 21, an interpretative gloss significantly more restrictive than the actual language connotes. Relating to, in the context of 18.1, are broad and unqualified words of nexus and do not require artificial limitation, even though it may be accepted that the nexus must be material. Now, I won't go to it, but a different Court of Appeal in Merinson, and that's M-E-R-I-N, Merinson, that's at 1496 at 1504, paragraph 30 of the judgment, said the same thing, and also said that that's a recent case. It also said that the Court of Appeal in this case was an application of that don't gloss principle. So in my submission, in Alpha Laval and Merinson relating to contracts of employment, individual contracts of employment, and in this case, in the Court of Appeal relating to matters relating to insurance, supported or following on from the Jordan case, which is a matter relating to insurance, there's a clear and distinct approach, both in the EU and in England, in favour of a simple wording, apply the words simply test, do not gloss them. Now, in our submission then, it's for my learned friend to make the running to say that there should be a limitation or a gloss. And he does so on the basis of, he says, EU authority. But the EU authority he relies on is Brogsitter, which is a case about Article 7.2, matter relating to contract, which is a derogation that requires to be looked at narrowly. And in this context, may I invite you to his, I think we can take it from his skeleton in the Brogsitter case for present purposes. That's page 241 of the bundle, which is core 1, tab 6C, page 241, paragraph 7. Paragraph 6, perhaps, I should start at, where my learned friends accept that the CJEU has not formulated a test of matters relating to insurance, and that is an end of the matter. But then it is submitted that the CJEU provided clear and authoritative guidance on the test to be applied for determining whether claim concerns matters relating to contract. Now, there's perhaps a psychological slip there. It's a matters relating to a contract is the proper quote. But he says Brogsitter. Before even reading Brogsitter, my primary submission is that it is wrong to import what is said about Article 7 or Article 7.1a in matters relating to a contract to matters relating to insurance. They are different matters. 7.1a is to be restrictively interpreted because it's a derogation. Article 14, for example, and Article 10 is not. At least Article 14 is not a derogation from the domicile of defendant principle, and it is unsafe and has not been done by any other court anywhere than possibly the Court of Appeal in this case, to import Brogsitter into matters relating to insurance. But my second submission is that when one reads Brogsitter, it actually, if, contrary to my submission, one is to import it into insurance, it supports my client. Because paragraph 23, my learned friends quote Brogsitter, paragraph 24 say that, and that is to say matters relating to a contract, is the case only where the conduct complained of may be considered a breach of contract. That's my learned friend's underlining, which may be established by taking into account the purpose of the contract. And then this is important. That will a priori be the case where the interpretation of the contract which links the defendant to the applicant is indispensable to establish the lawful or, on the contrary, the unlawful nature of the contract complained of. So now, a priori means as a matter of inevitable logical reasoning or something of that nature. In other words, in effect, always. And applied to this case, the contract that links the defendant to the applicant, in my case as defendant, is only the insurance policy of which I took an assignment and which I was a beneficiary, because I was not party to the settlement agreement. And it is also indispensable, as we've seen from the pleadings, to consider whether there was an insurance claim. So on that test, on the a priori test, even if you transport Brogsitter in, that is conclusive in the bank's favour. Over the page at 242.26, it's for the referring court to determine whether the purpose of the claims brought by the applicant in the case in the main proceedings is to seek damages, the legal basis for which can reasonably be regarded as a breach of the rights and obligations set out in the contract. That refers back to 24, may be considered the contract, and is subject to the a priori point, that it is a priori such a case where it's indispensable to consider the contract. And then we have paragraph 8, and with respect, paragraph 8 states the test that they contend for, but it is a misstatement of Brogsitter, if Brogsitter is relevant. 8 is, this means that a claim is a matter relating to contract, and it, once again the misquote, matter relating to a contract, where the subject matter of the claim is a legal liability for the breach of contract. But no, that is not what either 23 or 26, and certainly not what they, when read with 25, indicate. Misstatement even of the Brogsitter test. And this becomes very clear if we go on to 244 to 245 of this bundle and paragraph 18 and 19 of my learned friend's case, where they refer to Bosworth. Now, Bosworth was a case about matter relating to an individual contract of employment. But in that case, the Court of Appeal considered and applied the Brogsitter test, and there's the quotation, and there's an underlining of inquiry into the substance of the matter on the last line of page 244, and then the first line of page 245, still a quote from the Court of Appeal in Bosworth, with the result that it is indispensable to consider the contract in order to resolve the matter in dispute. So that is the Bosworth interpretation of the Brogsitter test as applied to individual contracts of employment. And my learned friend here does not demur from that, because in paragraph 19 it is submitted, the Court of Appeal in the present case cited the above passage and purported to apply the ratio of Brogsitter, paragraph 67. However, the Court of Appeal erred in its application, not in the statement of the test. So, notwithstanding what's in paragraph 8, in paragraph 18 to 19, there's acknowledgement that even the Brogsitter test is an indispensable to consider the contract test. And what then happens in my submission at paragraph 43, considering the application of the test, is that they revert to the paragraph, sorry, it's page 253 of the bundle, only by reverting to the paragraph 8 version of Brogsitter can they say that it's not a matter relating to insurance. First, applying the Brogsitter test, there's no claim against the bank which is based on a breach, or which may reasonably be regarded as being a breach. The subject matter of the insurer's claims, ... is not a legal liability for breach. So that's back to the paragraph 8 test, not the true test as demonstrated by 25 of Brogsitter and 18 to 19 of this very argument based on Bosworth. Posit, however, against me that the Brogsitter test is as per paragraph 8 at page 242 and is to be translated to the insurance sphere. And ask, oh well, is this a matter of legal liability for breach of contract? But in our submission, actually it is, because the essential issue in this case, well, translated, breach of insurance it would have to be, or breach of an insurance obligation. In this case, the allegation is an insurance fraud by the owner for which my client is vicariously liable in lying about the existence of an insurance claim. And that is either a breach of the contract of insurance or a breach of an obligation arising out of the owner's position as insurer. And in that instance, a breach of Section 17 of the Marine Insurance Act. And to make that good, can I invite you to the paper copy, the Supplementary Authorities Bundle, tab 3, which is the case of Versloot.
Do we have this electronically or not?
No, I'm sorry, my lady, this
I
came
think
in.
you may have sent it to the registry electronically.
We may have done.
Yes, I think you did.
You got it.
Yeah, I've got it in the email.
But perhaps I don't need to read it out. I just refer it's paragraph 8 of the judgment of Lord Sumption in Versloot, which was a case of a fraudulent claim on an insurance policy. And I won't read paragraph 8 out, it's page 46 of the bundle, 48 of the bundle, my friend very rightly corrects me. And in short, what his lordship said is that the better view is that the obligation not to make fraudulent claims is an implied term of the contract of insurance. But the alternative view is that it's breach of the statutory duty of good faith in Section 17 of the Marine Insurance Act. But either will do for my purpose, because the essential allegation at the heart of this case, the misrepresentation case, is that the owner broke either an implied term of the insurance contract or an insurance obligation arising under Section 17 of the Act by virtue of being an insured. And that is a matter relating to insurance.
There must be a general rule relating to all insurance policies, whether they're marine insurance policies or any other sort of insurance policy.
It is, my lady. It's been held that Section 17 of the Marine Insurance Act expresses the general rule applicable to all insurance.
Couldn't be a different situation.
But for present purposes, the question is whether it can be considered a breach of contract, if the test is whether it can be considered a breach of contract or liability for breach of contract. And the answer is yes, because the owner broke the contract or broke the general insurance obligation. And if you translate Brogsitter to insurance, it must be matter relating to insurance generally. Breach of an insurance obligation is a matter relating to insurance. And so my submissions are that even on that test, this is a matter relating to insurance. Now, in writing, we have made submissions on a number of cases that are relied on by the parties, and they are Profit at 995, Careda at 1286, Cabeg again at 937 and 8, and Flightright at 1720 and 1739. My submission is that all of those cases are inconsistent with what my learned friend says to be the Brogsitter test in paragraph 8, because they are all cases in which it was held that it was a matter relating to a contract where it wasn't a claim for or based on a legal liability for breach of contract. And I leave that as the general submission and also the particular submissions in writing, with one exception, and that is the Profit case, which is 995, which is Principal Authorities 2, tab 29. At 995 is the head note, and can I summarize this to be cross-checked against the head note of 995? This was a claim by a party who had paid money under an investment, a bond contract, and the relevant claim was that for a declaration of nullity, for various reasons that needn't detain us, and restitution of money paid pursuant to the allegedly null contract. So the present case is not a nullity case. Incidentally, Kleinwort-Benson was a nullity case, but let's not worry about that. But the question was it a matter relating to contract, given that the money was paid under something void? And at 995, 995 is the, what I've read, at 1026, paragraph 55, is the decision of the European Court of Justice, and they approve a point made by the Advocate General. So further, as regards the link between the action for a declaration of nullity and the recovery of sums paid but not due, it suffices to note as the Advocate General did, that if there had not been a contractual relationship freely assumed between the parties, the obligation would not have been performed and there would be no right to restitution. That causal link between the right to restitution and the contractual relationship is sufficient to bring the action for restitution within the scope of matters relating to a contract. It is not a claim for or based on legal liability for breach of a contract. It is a causation test. It's in effect a but-for causation test, but certainly it's a proximate causation test, if not that. It's inconsistent with the other side's submissions on Brogsitter, and that is in the context of a derogation from the general domicile rule. In the present case, had there not been an insurance policy, we wouldn't be here, if I can put it like that. So, in our submission, and I won't read it, but paragraphs 99 to 100 of our skeleton, our case, we submit that whatever version, on the plain and simple test, it's a matter relating to insurance. On the Brogsitter test, as properly understood, it's a matter relating to insurance. And even on the Brogsitter test, as my learned friends posit it, it's a matter relating to insurance because it's a matter relating to a breach of the contract, a breach of the insurance obligation. And that there's no basis for disturbing the Court of Appeal and the judge's decision on that, and no European issue of European law applies. Now those are my submissions on issue 2. So unless there are questions now, I move on to issue 3, and it's the weaker party exception. And my learned friends rightly characterize this at paragraph 50 of their case, 255 of the bundle, that's core 16C 255, paragraph 50, as being whether there is an exception to Article 14, the exception being the one found by the Court of Appeal. This is the one point that the bank failed and the insurers succeeded on below. The exception being for beneficiaries who are in a category of people who from time to time deal with insurance claims. So is there that exception? And my learned friends rightly in paragraph 50 at page 255 and in the heading characterize this as an exception. 3 points to note about that. Firstly, it's an implied exception, not an express exception, as we've seen. Secondly, it's an exception that would derogate from the rule of defendant's domicile, which is laid down in Article 14, and therefore contrary in my submission to the general approach in favour of defendant's domicile. And thirdly, it's an exception working against one of the specifically named parties in Article 14 who have been given the benefit of Article 14, namely the beneficiary, it being common ground that my client is a beneficiary. That is a very surprising exception, a very surprising implied exception. There is no EU case supporting an exception to Article 14, and the cases that my learned friend relied on are all about something else. The point can be put in 2 ways. Firstly, there is no basis for an implied exception in Article 14. Alternatively, secondly, if there is any implied exception for weaker parties, then by naming the beneficiary in Article 14, the statute has deemed beneficiaries irreversibly, and deemed means irreversibly presumed that beneficiaries are weaker parties. The further context, the further context of this is that when Great Britain acceded to the convention, they argued for a general exception in favour of big risks, that is to say, big and powerful insureds. And the Commission refused that exception on the basis that it was impossible to draw a demarking line, but instead granted an exception in favour of the British submissions in what are now Articles 15 and 16, but that exception was confined to the ability to contract out of defendant's domicile in large risks, one of which is marine risks, or in a category of risk, one of which is marine risks. So not only is my learned friend contending for, and did the Court of Appeal find, an implied exception, but they found it in the face of the British request for an exception, which was partially granted by granting a different exception, which did not exclude risks from the entire ambit of the insurance provisions, but merely permitted contractual derogation. So this implied exception is a more extreme one than the one that was asked for and partly granted. So we are looking here at an implied exception that is more extreme than the express exception granted. And the last preliminary point that I would note is that this exception is in fact based on, insofar as anything at all, the recital, number 18, that says that the insurance section serves the policy of protecting the weaker party. But as my Lord Hodge pointed out in the AMT judgment at paragraph 14, that is to confuse the text of the derogation or the article with the rationale for it, and to import something from the rationale into the test. It's also contrary to the other recital, 15, which is that the rules should be clear and predictable and in favour of the defendant's domicile.
So the rationale isn't the test, but the rationale may
inform the test.
Yeah.
I agree, but that raises what I might call the deeming point, which is the rationale is stated, and then it's carried into effect by the test, and the various courts have said that amounts to a deeming that the beneficiaries are within the rationale. Can I then just show you the Schlosser report to make good the submission I make about that legislative history? It's at page 1168, which is Principal Authorities, Volume 2, tab 39. And it's, I think, generally accepted that this is admissible. And 1166, so 1166 is the start of the section. And in short, without reading it, the United Kingdom asked for an exception for large risks. So paragraph 136, I won't read it, but that's context for what follows. And what follows is 1168, paragraph 140. The United Kingdom's request for special rules for the insurance of large risks was probably the most difficult problem, and the point was that social protection is no longer justified when policyholders are powerful undertakings. The problem was to find a suitable demarcation line, and then they didn't go with capital or turnover. The only solution was to examine which types of insurance contracts were in general concluded only by policyholders who did not require social protection. Special treatment could not be conceded to industrial insurance as a whole. Now, I'm going to submit later on that's in effect what has happened here. And then on the transport provisions, and then in the next paragraph, as a result of consideration of all these matters, is the solution which figures in the new paragraph 5 of Article 12 as supplemented by 12a, agreements of jurisdiction are in principle to be given special treatment in marine, and so on. So the special treatment is not, this does not apply to marine, it's that you can have jurisdiction agreements in marine. And that's why I said earlier on, the implied exception here goes wider than the express exception granted, and in effect reinstates, in my submission, the general exception for large risks posited but refused, but according to a test of, from time to time, deals with insurance, which would apply to every substantial entity with insurance. Now, I submitted, this was applied in the New Hampshire case in the Court of Appeal, and that's the electronic bundle pages 725 to 727, Principal Authorities 1 tab 10. I submitted below that this was binding on the Court of Appeal in my favour. Now that submission obviously is a mere natural history here, but I do submit that it's a case exactly in point. If I can then start at 717, which is the head note, and just 719, I beg your pardon, which is the head note, and just identify that this was an insurance contract between some very substantial German and Austrian construction companies, household names such as Hochtief and Bilfinger, and the New Hampshire Insurance Company. And the question was whether the New Hampshire Insurance Company could sue the German construction consortium in England, and the German construction consortium relied on what is now Article 14 to say that they should only be sued by the insurer in their own domicile, which was Germany. And one sees that at 721, in the beginning of the judgment of Lord Justice Lloyd, Article 11 provides an insurer may bring proceedings only in the courts of the contracting state in which the defendant is domiciled, irrespective of whether he is the policyholder, the insured, or beneficiary. So the German construction consortium said, we are the insured, we must only be sued in Germany. And at 722, the left-hand column, comes the argument that was rejected. The plaintiff, New Hampshire, say that the purpose of Section 3 is to protect those who are in a weak social or economic position. The defendants are 3 substantial civil engineering and construction companies, 2 in Germany and 3rd in Austria. They are in no need of protection, factually undoubtedly so. They have equivalent or comparable bargaining power, accordingly does not apply. And that was rejected at page 725 through to 727. I won't read them out, but I will note that at 726 there was reference to Professor Schlosser reinsurance contracts. Can I just, at 722, identify for you that not only were these construction companies, generally speaking, large, but as one sees from the first complete paragraph, about a quarter of a way down the right-hand column at page 722, since 1981, a variety of claims have been paid. The construction project was completed in 1987, but there was a 2-year maintenance period in 1989. The defendants prepared a large series of claims. Now that demonstrates, as you would expect anyway, that the Hochtiefs of the world, at least from time to time, and within their business advanced and collected insurance claims. And then, as I say, at 725, I won't read it, there's citation of the insurance articles. And at 726 at the bottom right, Mr. Pickering referred to Professor Schlosser. Mr. Pickering argued by analogy from reinsurance, and perhaps I should show you that 727, his lordship said, I'm not persuaded that the exclusion of reinsurance may not be justified on a narrow basis, namely that both insurers and reinsurers are in the same business of taking risks, and so on and so forth. And he says that whatever the reinsurance position, it is not applicable outside the reinsurance sector, and that will be my submission on another one of the cases, Jossie. Anyway, in my submission that was binding on the Court of Appeal, but if not, it's right. That the size of the insured or the beneficiary and its familiarity or otherwise with insurance claims is not a ground for accepting that part of the regulation. So we come to my learned friends' authorities for an exception to Article 14, and perhaps one way of doing this is by reference to page 257 of the bundle. That's Core 16C 257, and the cases that are cited from paragraph 58 onwards. None of these cases is about an exception to Article 14. Only one of them is about Article 14 at all, and that's the GIE and Zurich case. The rest of them are about parties trying to take advantage of the claimant domicile provisions of Article 11 and Article 13 in circumstances where they are not actually policyholders, beneficiaries, or insureds. And so on each of these cases, what has to be borne in mind is what section or what article is one under, and who is the person asking for the benefit of either Article 11/13 or Article 14. So in Girling, that's para 58 of my learned friend's submission, it's 1768 at 1770, but it was a claim by an Italian insurer in Italy against a German company based on a jurisdiction clause, and so is not is very far from our case. It was not a claim by an insured, policyholder or beneficiary to rely on Article 14 or Article 11 or 13.
Although the passage cited in paragraph 58 of the case is put in broad language, talks about the provisions of the insurance section. And one sees that sort of phraseology in some of the later cases as well. It talks about Section 3.
Yeah, the underlying provision, the underlying purpose is to protect the weaker party, and we accept that. Perhaps I should look at Girling. It's 1768 at 1770, which is Other Authorities 3, tab 65. Page 1780 is that paragraph. Well, I say, perhaps, I mean, the facts were a claim by Girling to rely on a jurisdiction clause. It is quoted in paragraph 58. Their purpose was to protect the insured, who is most frequently faced with a predetermined contract, the clauses of which are no longer negotiable, and who is in a weaker party. So the justification for protecting the insured is that he is most frequently weaker, but the protection is for the insured, and in my submission that applies to the infrequent cases, the justification being based on most frequently, that's the rationale, but the term being insured.
What's the page reference to that?
What, 1781?
1781.
1781.
Thank you.
I'm sorry, no, 1780. Yeah, 1780.
Thank you.
1781, paragraph 20 contains the rationale of the case, which is to do with jurisdiction, enforceability of jurisdiction clauses. Now, paragraph 59, group Jossi, that is at page 1071, Principal Authorities 2, section 32. This was the reinsurance case, where a reinsured tried to rely on the special rules of jurisdiction, and the ratio of the case, or the decision of the case, is that, in my submission, at page 1089, paragraph 74, it's paragraph 76 at page 1090 in the section that starts at 74. The ruling in the case is the answer to the second question must be that the rules of special jurisdiction in matters relating to insurance do not cover disputes between a reinsurer and a reinsured in connection with a reinsurance contract.
But paragraph 65 maybe is worth looking at.
Yes, my lord. That provides, I'll come back. There's 49 as well, but I'll come back to that.
Yeah.
So paragraph 65, in the reasoning towards that, the role of the protecting the party deemed to be economically weaker. And, my lord, that is the second way I put it, or as part of the first way I put it, which is that by inclusion within the list of named people, such as insured and beneficiary, is a deeming of weakness. The role of the protecting the party deemed to be economically weak and less experienced than the other party of the contract is fulfilled by those provisions, implies, however, that the application should not be extended to persons for whom the protection is not justified. And then paragraph 70, as has already been noted in 49 above, it is settled case law that the rules of jurisdiction which derogate from the general principle laid down in the first paragraph should not go beyond the express cases. And that interpretation is all the more valid because of point 2 of the first paragraph, Article 8, which is now 10.2, enables the policyholder to sue the defendants in the court of the domestic state. And for the reasons more set out in 50 above, there is hostility towards the attribution of jurisdiction to the courts of the plaintiff's domicile, otherwise than the cases for which it expressly provides. It follows that Title III may not be regarded as applying to the relationship between the reinsured and his reinsurer in connection with a reinsurance contract. And then they go on to Schlosser. And my lord, that was in the context of the reinsured trying to get the positive benefit of claimant domicile in Article 11, not of somebody trying to rely on Article 14 to argue for defendant domicile. And Lord, the key take points about this is that the general statement that there is a deeming of certain people to be economically weaker, they are the insured policyholder and beneficiary. And this case is about not extending the protection beyond the words to parties who are not economically weaker. So properly read in my submission, Group Jossi says, firstly, a beneficiary is deemed to be weaker, and that's the end of that exception. And secondly, it is a case about extending the rule of claimant domicile. And the answer is you should not extend the rule of claimant domicile other than to parties that are weaker. And, as I say, in those sections they refer back to 49 to 50, so I won't read them, but 49 to 50 make the point of construing derogations from defendant domicile in favour of claimant domicile narrowly. Paragraph 61 of my learned friend's case at 258 of the bundle is the Société Pelou case, and that is at 1030, page 1030 of the bundle, Plaintiff's Authority 2, tab 30. And at 1030 is the head note, and if I can just summarize the facts to be derived from here, it is that a Belgian company, on behalf of its French subsidiary, had an insurance contract with Belgian insurers. The French subsidiary was a beneficiary, and the French subsidiary tried to sue the Belgian insurers in the claimant's domicile, France, trying to take advantage of the provisions of the regulation that permitted claimant domicile. And if one goes to 1042, at paragraphs 85 and 86 in the opinion of the Advocate General, there is a reference to the accession issue and the limited exception there. And then at page 1049, 1050 in the judgment is the material part. So paragraph 30, between A and B, referring to the section in general, in the fourth line, they reflect an underlying concern to protect the insured, who is in most cases faced with a predetermined contract and is the weaker party. And that's a repetition of Girling. And the point is that the fact that in most cases the insured is weaker justifies protection for all insured, that being the difference between the rationale and the text of the rules. And 31, in insurance cases, contracts, the aim of protecting the economically weaker party is also insured by the jurisdiction rules. Then at the bottom of 1049, para 35, the Brussels Convention, and in particular Article 12.3, is talking about jurisdiction clauses, so perhaps I'll move on to 1050. And 37 is of assistance here. In that connection, it must be borne in mind that the beneficiary, like the policyholder, is protected by the Brussels Convention as economically weakest party within the meaning of Girling. And that again is a statement of what I might call the deeming principle. The beneficiary is protected as the weaker party because in most cases it, like the insured, is. So that, in my submission, that doesn't assist my learned friend. Then we have the GIE case, which is in his outline at his case at 63, page 259, and that is page 913 of the bundle, Principal Authorities 2, tab 24. And this this, as we see from 913 of the bundle, the head note, was a claim for contribution between co-insurers. And the French claimant co-insurer wanted to sue the Spanish co-insurer, Zurich España, in France. And Zurich España claimed protection of what is now Article 14, and this is the only case about Article 14 in the European, apart from Quebec, in the European cases relied on by my friend. And it was held that the protection of Article 14, as it now is, should not be extended to the Spanish co-insurer because it wasn't weaker. The point being that the Spanish co-insurer was not within the words insured, policyholder, or beneficiary in Article 14, so an extension to it was necessary. And so at 915, in the left-hand column, one sees what was then Article 11, there relied on by Zurich. Without prejudice to the provisions of the third paragraph, an insurer may bring proceedings only in the court of the contracting state in which the defendant is domiciled, irrespective of whether he is the policyholder, the insured, or a beneficiary. So Zurich say, I, the co-insurer, can have the benefit of that Article 11, now 14, but it's not a policyholder, insured, or beneficiary. It needs an extension. And at 916 and following, under the first question, at paragraph 16 to 22, which include the citations of my learned friend in 63, they are they, in my submission, say no extension is justified to Zurich because it is not a weaker party. But can I, at 916, show you paragraph 18, which makes, again, the point that I've identified, the deeming point, that the role of protecting the party deemed to be economically weaker and less experienced in the legal matters implies, however, the application of the rules of special jurisdiction laid down to that end by the Convention should not be extended to persons for whom it's not justified, and that is the nature of the debate. And then at paragraph 20, in these circumstances, no special protection is justified as regards relations between professionals in the insurance sector, none of whom may be presumed to be weaker position than the others. And then the Advocate General rightly pointed out, and this is perhaps important, support can be found for that view, in particular in Articles 8, 10, and 12 of the Convention, which clearly contemplate proceedings brought by a policyholder, insured, or injured party, and Article 11, which refers to proceedings brought against a policyholder, insured, or beneficiary. Now, those are now Articles 11 and 15. So in my submission, the correct interpretation of this is that the section deems certain named people to be weaker, and that includes beneficiary.
Your submission may perhaps gain support from the last sentence of paragraph 22. And that's referring to what was Article 12.5 and now is, I think, Article 15.5 of recast.
Yes.
Now, it doesn't actually exclude from protection, but it permits contracting out of, well, for example, marine insurance. And that's explained on the footing that contracts such as marine insurance and aviation insurance are contracts in which the insured enjoys considerable economic power, but obviously it's implicit in contracting out that they nevertheless fall within Section 3 unless you elect to or agree to contract out of it.
Well, the way I would submit it, in addition to that, is that the case of marine insurance, the potential greater economic power of the insured is catered for, I would submit exclusively, by the permission to contract out, which of course in this case, my learned friend's clients have taken advantage of, because in the whole policy they did contract out. Unfortunately, for them, in my submission, they only did so with the policyholder, the owner, and not the beneficiary. But yes, my lord. So the proper submission of this, as of all the cases, is that there are people deemed to be weaker, and they are the ones specifically named, including the beneficiary. The consequence of that is that they can sue in their own jurisdiction, Article 11, and they have the protective part, Article 14, that they may not be sued otherwise. The question in all these cases is, should that protection be extended to somebody who is not within the wording? And the answer is no, if they're not weaker. And in cases of marine risks and the like, the fact that they are not weaker is catered for by the permission to contract out, but doesn't require any wider rule. And to create a further exception would, as I keep saying, be in effect to reinstate the general large risk exception that was refused the United Kingdom. So that's G. Then at page 261 in my learned friend's case, at 68 is Vorarlberger. Now, Vorarlberger is the only case cited by the judge at first instance, and the judge at first instance found that there was a general exception for an individual party that is individually weaker, and he based that on Vorarlberger. The Court of Appeal overturned that. They couldn't support an exception based on the individual weakness of a litigant, but they replaced it with an exception based on membership of a class, which is not weaker in the sense that it, from time to time, deals with insurance cases. So that's the context in which Vorarlberger arose, and it's 2010, it's page 1111 I have got. It's Principal Authorities 2, tab 34, and 1111 is the headnote. And this was a case where the Social Security Institute, the Vorarlberger, which was Austrian, had succeeded to certain claims of an individual who had been involved in a car crash. So Austrian state social security succeeds to the claim of the Austrian victim of a car crash and wishes to sue on a direct action statute the German insurer, and wishes to do so in Austria. And one sees at 1111 in the left-hand column that they relied on what was then, in the first paragraph of the head note, 91b. So this is a case of the Austrian subrogee, which is a term used in the cases, claiming the rights of policyholder, beneficiary, insured, and a victim to sue in Austria under 911. And it was held that they could not, and I summarize, it was held they could not because they were not literally within the wording and were not deserving of an extension, being not a weaker party. So that is my submission on Vorarlberger, and my learned friends start to cite the case at paragraph 42, so perhaps we should go to 1116. And paragraph 36, we can perhaps start at, which says, in that regard, recital 11, now 15, the preamble, provides that the rules of jurisdiction must be highly predictable and on the principle that jurisdiction is in general based on the defendant's domicile. And that was relevant in this case because the German institution was seeking to rely on what is now Article 11, which is a claimant jurisdiction clause and therefore a derogation from the general rule of defendant jurisdiction. And then they go on to 38. Article 3.1 derogates from the general principle. 39, the rules on derogation from the general principle cannot result in interpretation which goes beyond the situations expressly envisaged. There is a theme in all EU cases, including my Lord Hodges, that derogations in favour of a claimant domicile are to be severely restricted. But of course that doesn't apply in this case because I'm relying on Article 14, which is a reaffirmation of the general rule of defendant domicile. 39 is to the same point, and then 40, below, the purpose of the section is to protect the weaker party. 41, the protective role fulfilled by those provisions implies that the application of the rules should not be extended. And of course, in the context of the case, it did need to be extended because we were talking about an Austrian state entity here. It's not been argued that it's economically weaker, 42. Consequently, a social security institution acting as statutory assignee of the rights of the injured cannot rely on the combined provisions of 9.1b and 11.2, now 11.1b and 13.2, in order to bring an action directly before the courts of its member state against the insurer of the person allegedly responsible for the accident. And then paragraph 44 is interesting. In contrast, where the statutory assignee of the rights of the directly injured party may himself be considered the weaker party, such an assignee should be able to benefit from the special rules. This is particularly the situation, as the Spanish government states, of the heirs of the person injured by an accident. So the ratio of this case is do not extend the benefit of a claimant jurisdiction rule, 11, to somebody not specifically granted that benefit unless, in fact, it or he is a weaker party. And that is the proper interpretation of Vorarlberger and does not support an exception to Article 14 where the benefit is explicitly given to the beneficiary. Now, my lord, my lady, over the page at 262, my learned friends rely at paragraph 70 on SOVAG. So that is page 1915, which is in OA3, other authorities, 3, tab 74. And the head note is at 1910, and I summarize it by saying that it was a claim by a subrogated Finnish insurer against a German insurer under a direct statute, and the question was whether the Finnish insurer could take advantage of the permissive rules, and at 1913, one sees what was Article 6, 8, and 11 that were then in play. So it's actually a different issue from the present one. But at 1915 is the part that my learned friend relies on. And at 29, sorry, according to SOVAG, paragraph 28, according to SOVAG, the regulation is not applicable because Section 3 establishes an autonomous system for the conferring of jurisdiction on matters of insurance. So So it's the Finnish insurers was relying on a section outside the insurance section. And the argument by Sovag, the German insurer, was that that was outside the section. Nevertheless, it must be pointed out that according to recital 13, the objective of that section is to protect the weaker party, namely the insured party, beneficiary or policyholder. So it's the namely there that supports the deeming provision. The action at issue concerns relations between professionals in the insurance sector and will not affect the procedural situation of the party deemed to be weaker. And essentially then the decision was that the insurance section does not take away the benefit of Article 6, which was then outside the insurance section. So my submission that case doesn't add anything at all to the debate. And then there's Cabeg, which my learned friends rely on in paragraph 71 and 72. And this is in we've been to it before, and it's 929. So Principal Authorities, Volume 2, Tab 36, 929. I summarised the facts before, but it's a subrogated employer suing on a subrogated Austrian employer suing a French insurance company under a direct action statute. And we've written extensively on this. But this is an important case because it is the source of the exception that the Court of Appeal found to exist and that my learned friend depends on. Now, I've already cited pages, or referred to pages 937 and 938, which relate to matters relating to insurance. And it's essentially 940 is important. In considering the insurance section. However, it ought also to be kept in mind.
Paragraph number?
I'm sorry, 47, AG 47, apologies, 940, page 940, AG 47.
Thank you.
It ought also to be kept in mind that in contrast with matters relating to employees and consumers, the notion of the weaker party in insurance-related matters is defined rather broadly. It includes 4 categories of persons, one of which is the beneficiary, my client. As a matter of fact, they may be economically and legally rather strong entities. That flows from the broad language of the insurance-related provisions of Regulation 40, as well as the type of insurance described therein. Thus, contrary to what is foreseen for consumers, the persons protected under Section 223 do not necessarily enter the respective insurance contract out of their trade or profession. This fact and this particularity of special jurisdiction ought to be taken into account when interpreting the notion of injured party. Now, that is clear authority for the proposition that there is a definition, this is the deeming point again, there is a definition of a beneficiary as a weaker party, and even though it may not be, it doesn't matter, because that is the purpose of the statute. That is the terms of the statute, as opposed to the rationale of the statute. Now, this paragraph, paragraph 47 was approved by the court at page 951, paragraph 32. Just look forward to that for a moment. As the Advocate General observed in AG 47, the notion of the weaker party has a wider acceptance in matters relating to insurance than those relating to consumers and employees. Now, with that, can I turn to page 942 of the bundle, turn back to 942 of the bundle, in the Advocate General's opinion, AG 65 to 67, and these will need to be read in context. But essentially, I summarize in 65 and 66, he is talking about the rights of a subrogee to use the claimant domicile exceptions of the regulation, and he departs from and deprecates what he describes as the Vorarlberger approach of trying to identify an individually weaker party and say that a subrogee who is individually weaker can have the extension of the benefits to it. That's my summary of those two paragraphs.
There's also 64 makes it clear that what he's suggesting is a change in what's become the boilerplate drafting of these judgments.
Yes, I think that's right. And what he suggests is at 67. So he suggests we shouldn't look at, in deciding whether to extend the protection to those not explicitly named, we shouldn't look at individual weakness, but at weakness of type. And at 67, I would thus suggest that the subrogation to the rights of the directly injured party triggers the passing of the forum actress to any subrogee, unless the subrogee is herself a professional in the insurance sector, to whom the claim passes on the basis of an insurance relationship she formed with the directly injured party, or the subrogee is an entity regularly involved in the commercial, otherwise professional settlement of insurance-related claims, who voluntarily assumed the realization of the claim as part of its professional and commercial activity. And then in the remainder of this opinion, I will further explain the proposed test by examining the relevant parameters that should frame the assessment of when the forum actoris passes onto a person asserting a derived insurance-related claim, and then the advantages of it. Now, 2 points to note about that. Firstly, he's making a law reform proposal in effect. But secondly, his proposal is for the circumstances in which the right to sue in your own jurisdiction, Article 11, forum actoris, which is not specifically given to you, should pass to you together with subrogation. In other words, he is considering when it is that the benefit of claimant jurisdiction should pass to somebody not specifically named, and his proposal is that it should do so when the subrogee is a professional or the subrogee is an entity regularly involved in insurance professional
Should do
sector.
so unless,
Yes, unless.
not when.
Sorry, yes. Yes. Yeah. But but this is a proposal for the transfer of the benefit of claimant jurisdiction with subrogation. It's nothing to do with our case, which is a question of an exception to the benefit of defendant jurisdiction, explicitly so stated in Article 14.
Does the Court of Justice pick this up at all?
Sorry?
Does the Court pick this up in its judgment?
The Court of Appeal in this case...
No. Does the CJEU pick it up?
It does not approve this. That's
Right.
That's one of our big points. This proposal for law reform is not picked up by the court. In contrast, I mean, I'm proving a negative here, but it's at 950 through to 952. And they hold that any employer may take the subrogated rights, in effect, because any employer is to be regarded as an injured party. So an employer who continues to pay is regarded as an injured party. But this particular exception is not adopted by the court. And as I say, that's my submission on that. I won't read it out in detail, but Cabeg is strongly a case in the bank's favour because of the court approving what I might call the deeming analysis in AG 47, and not a case in my learned friend's favour because the proposal for law reform of the Advocate General at 67 was not adopted by the court. But even if it were adopted, it's merely a proposal for the transfer of the benefit of the right of suing in your own action and nothing to do with Article 14. And I think, finally, my learned friends at paragraph 73, page 263, rely on the Hofso case, and that is at 918, which is in Principal Authorities 225, and 918 is the head note. My summary of the facts to be derived from the head note is that Mr. Hofso was a Polish, I might call it, hopefully not pejorative, a Polish claim farmer, in that he bought up claims of injured parties and then took assignments of them and then asserted them against the insurance companies. And he was a Polish gentleman in respect of a Polish accident, an accident in Poland injuring a Polish national. The insurance was provided by a German insurer, the LVM, Munster Insurance Company, let's call them. And Mr. Hofso, having bought the claim as an assignee, wished to rely on what is Article 11, I think what at this stage was Article 11, to bring the action in Poland. But he's an assignee, he's not a beneficiary, injured party, policyholder or insured, and the decision was, in those circumstances, the benefit of the forum actoris to be sued in the claimant jurisdiction, in derogation from the usual rule, did not extend to him. And that is at page 926 of the bundle. In general, at 33 through to 46, it's quite a long passage, and I won't read it out, but you've had my submission on it. But perhaps importantly, having considered the various weaker party points, at the top of 927 is what the case is about. Thus, the forum actoris, in other words, the right to sue in your own forum, must be extended respectively to the heirs, that's the Vorarlberger point because they're weaker, and to the employer who continued to pay the salary whilst he's on sick leave after the action judgment, that's Vorarlberger and Cabeg, MMAIard is also called Cabeg. Those decisions are based on the reasoning that it's to protect the weaker party and an assignee of rights of the directly injured party who may be himself considered a weaker party should be able to benefit from the special rules. So a weaker assignee can, in my analysis, have them extended to him. That said, the derogations must be exceptional in nature and strictly interpreted. We see that again and again and again in cases where somebody like Hofso wants to have the benefit of the claimant jurisdiction rule, nothing to do with our case. And then 41, in the circumstances, the protective function necessitates that the application of special rules of jurisdiction laid down in these provisions are not to be extended to the persons for whom that is not justified. No special justification where the parties concerned are in the professionals in the insurance sector. And then they say that just because Mr. Hofso was in business in a small way in buying up insurance claims, he was still a professional in the insurance sector. So that's at para 45. So my submission, none of those cases properly read apply. So in those circumstances, my submission is that the Court of Appeal went wrong. They went right in rejecting the judge's exception for somebody who is in fact a weaker party, but they went wrong in implying a further exception as they did in paragraphs 116 to 122, that is page 309, in Core Bundle Volume 2, tab 7B. The structure of this part of the judgment, which I invite reversal, is at page 309 to 310. His Lordship sets out the test under the heading Discussion and Conclusion, pulling the threads together. And then at 116B on page 310 through to 123, he applies the test, and we challenge both parts of this. And essentially, our submission is that 111 is where the error most clearly appears, although we submit it's all erroneous. I am unable to accept Mr. Berry's submission that the matter is concluded by reason of the bank being a beneficiary under the policy. And he says it doesn't give rise to an irrebuttable presumption, talks about undue literalness, and at the bottom of the paragraph will need to be read completely, but if the matter, he says, 6 lines up from 111, the base of 111, if the matter needs to be considered in terms of presumptions, then the definitions of the class listed in Article 14 may give rise to a rebuttable presumption that those named comprise the weaker party, Quebec 47, but in my view there's neither need nor justification for an irrebuttable presumption to that effect, and none of the CJEU authorities to which we referred spoke in terms of an irrebuttable presumption. Now, it's true that none of them used the word irrebuttable presumption, but that is what deeming is. Deeming is an irrebuttable presumption. And definition of weaker party is better than an irrebuttable presumption. So in my submission, this is to misunderstand the deeming provisions. And my second criticism of this paragraph is that it does not justify the positive implication of an exception. The Court of Appeal did not say, what is it that positively necessitates this implied exception, contrary to the wording and contrary to the rule of the defendant's domicile, in circumstances where there is already an express exception in different terms. So in my submission, what His Lordship there did was he knocked down, or thought he knocked down, wrongly in my submission, my conclusive argument in favour of the deeming and the definition as a beneficiary, but he didn't go on to say or provide sufficient reason for the exception. And in 112 and 113, insofar as he does so, he talks about protection not being extended, 112, and a case-by-case being impermissible, but he doesn't grapple there with the question that my client is not claiming an extension.
It's as though he's reading extended in the sense of, that it often bears, of really meaning provided, rather than stretched beyond what's actually expressed.
That's one possible reading, but in context, my lord, the word extended in all the European cases was used in contexts where the forum actoris was not provided to the litigant, or to put another way, the litigant was not within the expressly named list of beneficiaries, which includes beneficiary. And on the facts of those European cases, extended did mean stretched. Because in each of them, as I hope I've demonstrated, but submit again here, in each of them, the litigant claiming the benefit, usually of Article 11 for claimant jurisdiction, was not one of the named people, policyholder, beneficiary, and insured. And in that context, extended does mean stretched. And that is also illustrated by the Vorarlberger paragraph 44, which says that the heir who is weaker, who's an assignee, would have the benefit, even though the heir is not within the named provisions, that is an extension in the sense of a stretching, if stretching is the right analysis of that. But if extended is to mean defined to cover or covers anyway, then my other submissions, the answer is the other submission, which is the deeming submission and the definition submission, wherein I'm quarrelling with paragraph 111 and the lack of need, let alone authority, for this exception. Anyway, the exception provided for is in 114 at page 310, and it is in the terms of the Attorney General in Quebec, who, as I said in answer to my Lord Kitchen, was not approved. In the fourth line of 114, he goes to that Quebec situation, and then he applies that test later on, and my submission is there is no such exception. Now, at this point, and if I may have another 4 minutes, at this point,
You'll need another 4 minutes, will you? Okay, well, it comes off your reply time, as you know.
So we're on to application of the test. So those are my submissions on the test. In terms of the application of the test, this doesn't raise any important point of EU law, and it is, in effect, an appeal on a point of fact, for which, nevertheless, I have permission. But it arises in these circumstances that the fact relied on by the Court of Appeal in paragraph 119 is that as an ordinary incident of its ship finance business, the bank must have been involved from time to time in the commercial or professional settlement of insurance-related claims. And one notes immediately that that fact is different from the test stated in 111, which is regularly involved in the commercial or other professional settlement of the insurance-related claims. And so, although it's an appeal on a point of fact, my submissions are unusually in this case, it should be admitted and allowed, because it was not a fact that was an issue before the judge, where the question was, if anything, of the actual weakness of the party. And there was no evidence either way on this, except for what happened in the instant case. And in the instant case, the bank was wholly uninvolved in the settlement of the claim and left it to the owner. So there's no evidence in support of a finding of regular or from time to time involvement. And such evidence as there was, i.e. what happened in this case, was to the contrary. And given that this is a point of fact that only arose in the Court of Appeal, my submission is that this court is equally able to make a finding on it, bearing in mind also the burden of proof, which is on my learned friend to establish jurisdiction. And so to summarize, there's no basis for that fact-finding. The fact-finding doesn't actually comport with the test, which is regularly involved. The fact-finding is from time to time involved, whereas the test, if it's a good test, is regularly involved. And at 120, on the basis of that finding, which we dispute, that my client is from time to time involved in the professional settlement of insurance claims, the question is it akin or analogous to an insurance professional? And my submission is not. When considering the weaker party, which is the foundation for all this, is a bank like my client, which from time to time, if that be right, settles insurance claims, a weaker party to Lloyd's of London, AXA, and the Allianz, the giants of the insurance world, who spend their whole time doing insurance claims. So my submission that from time to time involved as, in effect, a side issue, at best makes you a part-time professional as an exception to your main job, which is lending money. And if one is considering the weaker party category, then such a category of persons like the bank is weaker than the full-time professionals of the hull insurance. I'm sorry, those are my submissions.
5 minutes.
Yes, I'm sorry, I've taken a minute.
Worry not.
I,
It's up to you what you do
Right.
with the time that you
Yes,
have.
there are.
Yeah.
So I do say much of what I've said has been written at greater length, but we'll rely on that. Don't know if there are any other questions.
Thank you. Mr. Broad? Mr. McDonald,
My lady and my lords, just to locate issue 2 in context of the dispute as a whole, the issue 2 is whether the insurance section applies. And of course, this assumes my clients have lost on issue 1. If the claim is within the insurance section, then jurisdiction is to be determined according to Articles 10 to 16. If it does not fall within the insurance section, then jurisdiction is to be determined according to Articles 7.1 and 7.2. If the insurers therefore do not succeed on issue 1, and if the insurance section applies, then the court then does not have jurisdiction. But we say that the insurance section doesn't apply for 2 reasons. One is issue 2, that this is not a matter relating to insurance, and issue 3, that the bank is not an economically weaker party who should be afforded the social protection offered by the insurance section. Dealing with issue 2 first, my learned friend and I think, are agreed that the European Court has not yet identified or laid down a test of what constitutes a matter relating to insurance. I should point out to the court that, and the court may well remember in relation to a case called Hotel Penares against Keefe, that this court referred the issue concerning matters relating to insurance to the European Court, but I think the matter was settled before it was determined. But there is a pending reference made by the High Court in September of this year, which was on fact similar to the Keefe case, and that reference has not yet been determined. It was only made in September, but it will be concerned with what constitutes a matter relating to insurance. And this reference is referred to in our written case, or reply written case, but the court ought to be aware of that. But the facts giving rise to the issue in that other case are not similar to the facts arising in this case. They're materially distinct. But it may well be that the European Court will comment on what matters relating to insurance means.
And presumably, if we decided that this issue was act clear against you, there would be scope to the parties in that case then to apply back to the High Court to terminate the reference.
Perhaps, depending. The fact, as I say, the factual scenario is a different one. It's concerning what it's been described as and unkindly described as a parasitic claim, where there's a claim brought by an injured party against an insurer, but there's also a claim by an injured party against the wrongdoer in relation to the uninsured element. So the question is whether that latter claim is a matter relating to insurance. So with that, and my learned friend has very rightly identified that the substance of my submission is for this court ought to construe the phrase matters relating to in section 3 consistently with the European Court's interpretation of matters relating to contract in Article 5. Article 7. And it is worth bearing in mind that the Court of Appeal, in particular in a case called Bosworth against Arcadia, did consider and apply the Brog-Sitter test in dealing with another section, which is section 4, which is matters relating to employment contracts or contracts of employment. So, and we say that there is good reason to apply this jurisprudence And it's this, that the regulation uses the very same phrase, matters relating to. It's the same connective phrase, and the intention, therefore, would be that the draftsman of the regulation would have intended the same phrase to have the same meaning in all contexts. And it's a phrase which is not only used in Article 7.1, but in each of the social protection sections, sections 3, 4, and 5. Now, my learned friend rightly refers to the fact that if you, perhaps it's best to take it out, it's PA1, tab 15. And if you could turn to page 799. You'll see the heading of the section number 3, which is jurisdiction and matters relating to insurance. And page 800 on the next page. So I think I said section 4 was employment contracts. It's actually consumer contracts. But section 4 on page 800 refers to jurisdiction over consumer contracts. But you'll see in Article 17, subparagraph 1, in matters relating to a contract concluded by a person, the consumer. So again, it's the same phrase, matters relating to.
But the focus seems narrower. And there you focus down on a specific contract. I think the point being made in the heading to section 3 in Article 10 is that it seems more general.
Yes, that's the point I'm about to address. And that's why, if you look at section 5 as well, you'll see reference to contracts of employment as opposed to employment. Now, the fact is that the submission before the Court of Appeal, which I think was accepted, and I can take my lady and my lords to that, if we go back in this document to recital number 18, which is at page 794, you see in relation to insurance, consumer, and employment contracts, the weaker party should be protected by the rules of jurisdiction more favourable to his interests than the general rules. And in recital 19, the autonomy of the parties to a contract, other than an insurance, consumer, employment contract, where only limited autonomy to determine the courts having jurisdiction is allowed, should be respected subject to the exclusive grounds of jurisdiction laid down in this regulation. So my submission is that even though the Section 3 begins with the words in matters relating to insurance, the intention is to deal with matters relating to insurance contracts or an insurance contract. And that's reflected in recitals 18 and 19. And it makes good sense because there are many, many relationships in the insurance industry which are not intended to be covered by Section 3. For example, a broking relationship between an insurance broker and the broker's client. That's not intended to be covered by Section 3, and yet it would be regarded as a matter relating to insurance rather than an insurance contract. And I can go on, but and this, I think, was accepted by the Court of Appeal below. And if I could ask...
Sorry, just on recital 19.
Yes.
I mean, isn't that directed more specifically to Article 15, which is the power to exercise autonomy by making specific agreements as to jurisdiction?
Yes, but I think my point is that the fact that recitals 18 and 19, my lord, refer to insurance contracts as opposed to matters relating to insurance, that the intention of Section 3 is that a matter relating to insurance means matters relating to insurance contracts.
But recital 19 is just talking about the autonomy of the parties to a contract. It doesn't say insurance contracts.
No, yeah, but other than an insurance, consumer, or employment contract. So it's referring to...
Oh, I see what you mean.
Yes.
Right, I'm sorry.
And 18, of course, does refer to insurance, consumer, and employment contracts. I'm sorry if I hadn't made it myself clear. The other point, and of course, as we say in our written case, there are other references in the regulation which referred to contracts, the insurance contract, which, for example, this is referred to in our written case, Articles 26.2, 31.4, and 45. But this point, I think, was accepted by the Court of Appeal below. And if I could ask the Court to look at CV2, tab 7, tab B, page 298. It's at paragraph 71, subparagraph 2. And this section actually begins is a concern with the Court's conclusion. And the Court, again, this is, of course, is a matter where the Court didn't accept my submission on matters relating to insurance, but the Court did accept my submissions to an extent, and you can see that set out in subparagraphs 1, 2, 3, and 4. And the relevant one here for our purposes is 2, which the Court said nothing turns on the absence of the words contracts in the heading of Section 3 by contrast to the wording in headings of Section 4 and 5. Aside from any other consideration, the word contracts or contract is applied in recitals 18 and 19 in an undifferentiated manner to insurance as well as consumer employment matters. And then the Court proceeds to consider the Brogsitter decision in this context. And therefore, when you have Article 7.1, Articles and Sections 3, 4, and 5, all using the same phrase, matters relating to various types of contract, then it's likely that the European Court and indeed the draftsman of the regulation would understand that phrase would be interpreted in the same way. And that's why we're relying upon Brogsitter. Now, the Court is basically faced with a choice of two courses. The first course is the one I prefer, which is the Brogsitter approach. The second course is the approach which has been adopted by the English Court of Appeal in a number of decisions, including in this case, which suggests that the Brogsitter test shouldn't be interpreted, at least as I suggest, but based on a material nexus approach. And I'll make that point good by reference to the authorities. But we say if you just adopt a test of a material nexus or a test of a matter arising out of an insurance relationship, that's far too broad and does interfere with the principle of construction, which is you construe derogations from jurisdiction in a restricted manner rather than a broad manner. It also means that this test of what constitutes relating to insurance can be applied predictably rather than uncertainly, and just yes, and and the notion of predictability is referred to in recital 15. So, if I could ask the Court to look at Brogsitter, which is at PA 2, tab 22. At page 879. Now, this was a case concerning with the equivalent of Article 7.1, which is matters relating to a contract or contract. And my learned friend picks me up on by saying I've often left the word a out rather than, I say matters relating to contract or a contract. But I'm in good company because the European Court often does as well. But I don't think anything turns on the missing article. So if we look at page 879, and I should make it clear, this is a claim for unfair competition, fraud, and breach of trust against the defendant.
Sorry,
which
paragraph?
It's going to be paragraph 20, but I'm just summarising what the case is about. So it's a claim for unfair competition, fraud, and breach of trust against the defendant with whom the claimant had a contract for the development of watch movements. And the basis of the claim was that the defendant carried out work for other clients, and the claimant suggested that they had an exclusive arrangement between them. And it's paragraph 20 at the bottom of paragraph 879, and there's a reference to what which matter we've looked at, which is it's apparent from settled case law that the concept of matters related to tort, delict, or quasi-delict within the meaning of Article 5.3 covers all actions which seek to establish the liability of a defendant which do not concern matters relating to a contract within the meaning of Article 5.1. And on the next page, paragraph 21, in order to determine the nature of the civil liability claims brought before the referring court, it's important first to check whether they are, regardless of their classification under national law, contractual in nature. It's apparent from the order for reference that the parties to the main proceedings are bound by a contract. However, the mere fact that one contracting party brings a civil liability claim against the other is not sufficient to consider that the claim concerns matters relating to a contract within the meaning of Article 5.1a of Regulation number 44. That is the case only where the conduct complained of may be considered a breach of contract which may be established by taking into account the purpose of the contract. Now, just pausing there, what the court is saying up to this point is that the relevant, as a matter of European law, the relevant claim must be contractual in nature, and that the parties to the proceedings are bound by a contract. But the mere fact that there is a claim between contracting parties doesn't make it a matter relating to a contract. It will only be a matter relating to the contract, and this is Article 24, paragraph 24, where the conduct complained of may be considered a breach of contract which may be established by taking into account the purpose of the contract. So what the court is saying is that the nature of the relevant claim, for it to be a matter relating to a contract, must be a claim which can be regarded or considered a breach of contract, therefore a breach of the rights and obligations under that contract. Now, in paragraph 25, the court goes on to say that will a priori be the case where the interpretation of the contract which links the defendant to the applicant is indispensable to establish the lawful or, on the contrary, unlawful nature of the conduct complained of against the former by the latter. Now, my learned friend relies upon this notion of indispensability. However, indispensability alone is not enough. This is an additional example, but the key requirement is that set out in paragraph 24. So without that requirement in paragraph 24, even if it's indispensable in other ways, that won't make it a matter relating to a contract. And then in paragraph 26, the court says, it is therefore for the referring court to determine whether the purpose of the claims brought by the applicant in the case in the main proceedings is to seek damages, the legal basis for which can reasonably be regarded as a breach of the rights and obligations set out in the contract, which binds the parties in the main proceedings, which would make it take into account indispensable in deciding the action. So you can see there the court is linking expressly the fact that the claim must be for a breach of the rights and obligations of the contract with the notion of indispensability. Now, it's fair to say that this test of what constitutes a matter relating to a contract has been extended to deal with two particular scenarios. One scenario, which my learned friend referred to when he referred to this, the decision in Profit, which is this, that where the object of the claim is to annul or avoid a contract, that will still be a matter relating to a contract. But I'll come back to that point. And the second point is that where a third party is seeking to exercise the rights belonging to a contracting party, such as a subrogated insurer or an assignee, then again that may well be a matter relating to a contract, because it's the rights under the contract which are the subject matter of the claim. So in the context of just pausing there, the context, if we apply that Brogsitter test to matters relating to insurance, therefore the relevant claim must be one which is for breach of the rights and obligations under the insurance contract, not any other contract, the insurance contract. And just to make this point good, therefore, if you have, for example, an assignee, such as the bank in this case, because the bank is an assignee exercising rights of an assured under the contract, and the assured, of course, has an insurance contract with the insurer, then that would be a matter relating to an insurance contract. However, by contrast, if there was a claim against a solicitor for negligence in drafting an insurance contract, now in one sense that's a matter relating to insurance, that would not fall within the scope of a matter relating to insurance under Section 3, nor could it. Now, my lady and my lords, therefore, my learned friend referred to our pleading, referred to the fact that what is the subject matter of the claim is against the bank is a claim in damages for misrepresentation and a claim for restitution by mistake. I don't accept, by the way, but it's not for this court, that my clients don't have a claim in restitution against the bank and the avoidance of the settlement agreement. That's not important for this purpose. But in both of those cases, misrepresentation and mistake, the misrepresentation and mistake are, if you like, informed or constituted by the position under the insurance contract. But the claim against the bank is not a claim for breach of the rights and obligations under the policy. Indeed, as my learned friend has constantly said, the bank is not a party to the policy. Now, my learned friend in paragraph 100 of his written case, and I don't need to ask you to read it unless you wish, but for your note, the reference is CV1, tab 6B, page 211. My learned friend identifies a number of tests which could be adopted to identify whether a matter is a matter related to insurance. And he identifies the material nexus test, the indispensability test, a test based on causation, and a test based on the matter arising out of the insurance relationship. Now, I think the Court of Appeal below said causation is not enough. It's got to be something more than that. But the Court of Appeal, in this and other cases, has referred to the material nexus test, and I'll come back to that after the break. I think the one point I'd like to deal with just before the break, if I may, and of course, I'm perfectly willing to be stopped at any particular time.
Well, I always go by the clock on my computer, which is not necessarily accurate, but you've got 2 minutes.
Before lunch, not before the end of my submissions.
Oh, no, you've got a lot longer.
So it's the Cabeg decision, which is a PA2, tab 26.
Page 729? 929?
938.
928.
And this is dealing with I'll come back to the material nexus test. This is to deal with the notion that the claim must arise out of an insurance relationship. And it's the Advocate General's, this is Advocate General Bobeck, who said at paragraph 36 and 37. My learned friend took you to 37, but I don't think, I'll be correct if I'm wrong, he took you to 36. And the Advocate General says, I do not think that it would be either necessary or wise to attempt to provide a general and exhaustive definition of what is a matter relating to insurance, and hence what is insurance. That can be left in the hands of legal scholarship. There is, however, one element that emerges from the reviewed case law naturally tied to the logic of the Brussels Convention regulation system. For the purpose of international jurisdiction, the basis for ascertaining what is a matter relating to insurance is essentially title-based, is the title for which an action is launched against a specific defendant, in other words, the cause of that action, the ascertaining of rights and duties arising out of the insurance relationship? If yes, then the case can be deemed a matter relating to insurance. And then my learned friend did, I think, refer you to the next paragraph. A matter relating to insurance then simply concerns the ascertaining of rights and duties of any of the parties, referred to the extent that these rights and duties are said to arise out of an insurance relationship. Now, the important point here is, of course, the insurance relationship is constituted by a contract. And the second point is that the Advocate General said it was title-based. Now, after the break, the Advocate General explains what he means by this in a subsequent opinion, and I'll come back to that. But if that's convenient, my lady.
Yes, thank you.